record with Mr. Gates. Mr. Gates, I've given you an opportunity to speak to counsel. Counsel, the client wants to take the deal.
Yes, Your Honor, he will plead to the amended count of failing to display.
Is that what you want to do, Mr. Gates?
Yes.
Can you raise your right hand, please? You have to turn your camera on, sir. If you can't raise your hand in the chat. Do you swear or affirm to tell the truth, whole truth, and nothing but the truth?
Yes.
I do.
Not you, Mr. Griffin, Mr. Gates. I can't hear you, Mr. Gates.
Yes.
All right, you can put your hand down. You understand the maximum possible penalty for this offense? He's sitting in the driver's seat now, aren't you?
No.
Wait a minute. Wait a minute. Here we go again. Mr. Gates.
Mr. Gates.
Yes.
Mr. Gates. No. Don't say anything, counselor. Mr. Gates, are you sitting in the driver's seat of a car now or not?
No.
Or where are you sitting?
Passenger.
You're sitting in the passenger seat
I
of
mean,
the car?
Yeah, I'm in the driveway of my house. Yeah, at my house.
I didn't ask you that. You said you were sitting in the passenger seat of the car, right?
No.
You didn't just say that?
No.
All right, what we're gonna do is we're gonna have Mr. Gates come in person because I think Mr. Gates is lying to me. All right, so we won't have to worry about you sitting in the what I believe you sitting in the driver's seat of the car. Where are you sitting in the vehicle, sir?
Driver's seat of the car.
And you just lied to me. Is that correct?
Yeah.
All right, you're coming in person, sir.
For sure. What time and date?
It's going to be May the 30th. May 30th.
What time?
At 9 a.m. There's nothing further, sir. I'll see you in person May the 30th at 9 a.m.
Hey everybody, welcome to American Courts. Got an interesting show for you. We got a long one in Bay County with Judge Clark. One of my favorite judges. I like the way he handles court and no nonsense. I don't have a lot to say, so we're just going to jump right into it. So we're going to jump in. Let's go to Judge Boyd.
Court is calling 2025 CR 004086. All right, we're back on the record. Could I have parties announced for the state? Defense?
Anita Perez for the defense.
You're charged with assault, family, household, impeding breath or circulation, and in cause number 2025 CR 004086. You're charged with violation of bond or protective order 2 times or more within 12 months as a third-degree felony. Range of punishment in each of those cause numbers is anywhere from 2 to 10 years in prison and up to $10,000 fine. Plead guilty, not guilty, or no contest?
No contest.
All right. So in the cause number, and maybe I don't see it, in cause number 86, I don't see the other dates.
What those dates are referring to, which I guess we could figure out how to put in the situations where those were days that the defendant called the victim from jail. So those would be reported to jail.
All right. So
And we've been provided with those, Judge.
I'm sorry.
We've been provided those.
Well, are you stipulating that because he pled no contest? Is there a stipulation that he made phone calls to the complainant from the jail on December 6, 2024 and December 11, 2024?
So as far as that, Judge, we're pleading no contest. My client has no prior offenses.
No. I'm trying to see if there's.
I'm trying to get there as to our application we are applying for deferred adjudication. And so because of that, I would not want him to make any stipulation. So that's why I asked him to plead no contest. Because if the court should grant him deferred, then.
Well, here's the thing. I don't have that in the stipulations to prove the 2025 CR 004086. Now, if somebody wants to amend this and attach jail calls, they can attach it, but I don't have enough proof in here for these other dates. The only date that I have in the stipulated evidence is I have a date from January 5th for violation of protective order. But the other dates I don't have in here. So if y'all want to step back, you can, but in cause number 2025 CR 03533, the court is finding that there's sufficient evidence to find you guilty. The court will defer finding of guilt. It takes about 8 weeks to 12 weeks for a PSI. If you would like to have him come back without a PSI, but just have time to call witnesses, you're more than welcome to do so.
So I've conferred with my client, and I've also contacted family members, and my client wishes to waive PSI, and just have the court, and that was why we took a little bit of a recess, Judge, before we got on the bench, is just to confirm the criminal history. And so at this time, we're asking the court to waive PSI, and we proceed with sentencing today.
So here's the thing, if he's not going to stipulate that what's in the indictment, the dates, then we can't proceed. I can't proceed on those dates. And if there's no additional information that's given to the court, then the court is going to find him not guilty of this because.
And Your Honor, if I may ask Jones for record, all that's required for the statute is 2 offenses within a 12-year period. The first offense is going to be December 5th, which is listed in the report, and then the second offense would be the January 25th date, which is in the report. So that would be 2 violations within a 12-month period, and we can scratch or amend the.
All right, so y'all want to admit. All right, so we're back on the record. All right, you're correct. And you're saying that you wish to waive PSI?
That's correct.
All right, what do you wish to say on behalf of your client?
Your Honor, my client, he's 27 years old. He is not native to Texas. He's from Indianapolis, Indiana. I'm sorry? Chicago, Illinois. I apologize, but he, as mentioned before, he's 27 years old. The victim and him are obviously very familiar. They've been together since they were children. So I think since they were like 16 years old. Is that right? 16? 15. Since they were
All right, does he
15.
want to testify?
No, Judge. Just let me just finish. I'm so sorry.
All right, so you can't get information from him, then turn back to the court to give whatever information he's given you if he's not going to testify.
Okay, I'll just
All
proceed.
right.
I'm sorry, Judge.
No problem.
And they do have 3 children together. And obviously they've had a myriad of things happen, I guess, in their lives, and they have both matured and progressed. And my client wishes to accept responsibility. He understands that the only way he's going to see his children, because that was another thing that we talked about, was that there will be a no contact order. That is something that obviously he's vehemently opposed because he does have 3 children. And so I did advise him that this would be part of the plea agreement, and if he wants to hire a lawyer and get some custody issues and orders in place so that they can go around that order, in order for him to be able to see his children, because obviously the state is not asking for a no contact order with the children. It would only be with the mother, the natural mother, which is the victim here. I have spoken to his father. I am not sure if yesterday he was on the Zoom and standby, and I mentioned him that he would at the same time today, and I don't know if he's in the waiting room or not, but notwithstanding, my client does want to go forward. His father obviously speaks very highly of him. Unfortunately, he did get arrested in February 27th, which is when he got booked for the last time. So he's been obviously in custody for almost going 3 months now. He's got health issues at the jail, Your Honor. He's got psoriasis. He lost about 110 pounds in those 3 months. So he's had some kind of health limitations. And so a lot of that is going into why we have this agreement. Obviously, I've explained to him multiple times, that we could ask for a jury trial from the court. But given the history with these people, that obviously he wants to accept responsibility, and he's wanting to do that today, Judge. And with respects to just putting it on the record, I do want to state that, we took a little bit of time going over the criminal history. There was a jury trial that happened in December of 2019 in Indianapolis, Indiana. So that's why, I'm sorry, I was confused about the city, that there was an actual jury trial and he was adjudicated not guilty with the same victim. There was also, I want the court to take judicial notice of cause number 2025 CI 04103. There was an application for protective order that was made by the victim February 25th, 2025, and it was non-suited in April 17th of 2025. My understanding, and prosecutor wouldn't really talk to me too much with respects to the protective order, Ms. Colon, but she did confirm that it was non-suited due to her leaving the state. So the victim.
Due to what?
The witness leaving the state.
Okay.
So as we stand here today, we have, obviously my client hasn't had any contact with her since then. And then, but she has been in contact with the state, which obviously, we know that is for a fact, but obviously he's very concerned for his children. He wants to know their whereabouts. And he did meet with a recruiter, and I did speak to him on the phone. He would not come in for the PSI. His name is, Eggerson is his last name, Sergeant Eggerson, and I did call the number. Unfortunately, Mr. Ross was in the process of being recruited to the Army. And so obviously he understands that accepting responsibility for this charge, and should the court grant him deferred, he will not be able to possess a weapon while he's on deferred. But the hope, I guess, is that once he's completed the deferred, is that he'll be able to enlist at that time. So our agreement right now is 4 years. Now the court can give him probation, the court can sentence him, or the court can give him deferred, which I believe he's legally entitled to because he has no convictions.
What do you mean he's entitled to deferred adjudication?
Okay.
Legally?
Well, I would ask the court to take that into consideration, that he has no legal convictions under any other ordinary circumstances. He has no prior offenses.
Okay,
but convictions. And so,
but if you're saying
he's a first-time offender.
All right, but if you're saying he's legally entitled to deferred adjudication on this case?
I have no statute.
Oh, right.
If the court, I have no statute, but I'm just saying as a matter of principle, as a matter of, mercy on my client, the court, I should hope, at least, because again, he's also been in contact with, being recruited, that he would be granted deferred adjudication. And, he wants to move on with his life. He wants to start probation. He understands that should the court grant him probation, he'll have to be here for 45 days, right? You understand? You understand it? And that if he wants his probation to be transferred to Indiana, it'll have to be transferred within that time frame.
All right. So what I can
and
tell
he'll
you,
have to accept the
he's not a
transfer.
good candidate for probation.
He's not?
No, he's not. And let me just tell you why. Based upon everything that I've seen, there was a protective order in place, and you were calling the complainant from the Bexar County Jail. I mean, does he not understand what no contact means? No contact means no contact. And then we have this charge where you're choking her. So he's not a good candidate for probation. I'm not giving him probation.
Well,
In each cause number, I'm finding him guilty. I'm going to sentence him to 4 years in the prison, give him credit for any time served. There's a $1,500 fine, time and money to run concurrent. The cases are to run concurrently. There's to be no contact with the complainant and no contact with minors. And cause number 2025 CR 003533. There's an affirmative finding of family violence. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal in each cause number? With your attorney, did you understand it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because one of these cases carries an affirmative finding of family violence, and also because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney.
Sorry, may I speak to my bad, please?
Your attorney said that she did not want you to speak. The court has passed sentence.
I didn't know that I couldn't. I thought I had the whole time to testify. I thought she would.
I asked you if
All
you
right,
were
so,
for jury trial.
They're going to take you back. If
Can I
there's something
please-
else you all want to discuss, if you want to file a motion, you can file a motion and the court will hear that
Please
motion.
speak on my behalf. Can I please speak on my
I don't know what
behalf? I just want to testify. I didn't.
Patrick Washington,
Well, that hearing made me happy. I hadn't been able to see the end of that, so that made it better. All right, so Kimby's going to telling everybody. So make sure to tell everyone happy, or tell Margaret. I constantly mess up her name. Tell her happy birthday. Thank you, Kimby, for mentioning that. And let me figure out my dang microphone. I don't know why it's acting up. We're going to jump to. Let's jump to Ohio. Got a quick one.
Do you have a copy of the complaint, Mr. Wright?
I do not. Oh yeah, I do.
Okay. Court is on the record in State of Ohio versus Kyle Wright Jr., case number 25 CRA 152. This case is set for an initial appearance hearing on a criminal charge filed against Mr. Wright. Mr. Wright was arrested as a result of the criminal charge, and he is appearing at this hearing by way of video from Ashtabula County Jail. Mr. Wright, for the record, you have received a copy of the complaint?
Yes.
Okay, I'm going to read you your rights, so please pay attention to the rights I'm about to read to you. You do have a right to be informed of and to understand the nature and the elements of the charge filed against you. You also have a right to know the potential penalties that could be imposed. You are charged with one count of arson. That is a 4th-degree felony. If convicted of this offense, you face anywhere between a minimum 6 months up to a maximum 18 months in jail or prison, a maximum fine of $5,000, and if you did receive a prison sentence and are released from prison, you would be subject to post-release control for up to 3 years. So do you understand the maximum potential penalties you face if convicted of this offense?
Yeah.
Oh, yeah. Yes?
Yes.
Okay. Also, if you're convicted of arson, you would be required for a period of time to register as an arson offender with the Ashtabula County Sheriff's Office or the Sheriff's Office where you reside. So do you understand that potential consequence?
I would not be allowed. Yeah, I do. I'm not allowed. I wouldn't be allowed to live in that area. You said.
No. Can you hear me okay?
There's a little bit of noise in the background.
Is there a way you can kind of have that door closed a little bit? I mean,
You can't shut it all the way. If you just repeat what you said, the last part.
okay, Mr. Wright, if you are convicted of arson, you would be required to register.
Okay.
Let me finish, sir. Don't interrupt me.
Sorry.
You would be required to register with the Ashtabula County Sheriff's Office or any sheriff's department where you are residing for a period of time. Do you understand that?
Yeah.
So your only 2 plea options are not guilty or no plea to this charge. So Mr. Wright, do you understand all of the rights and plea options that I've just explained to you?
I do. Yes.
Okay, so with respect to this charge of arson, a 4th-degree felony, how do you plead?
Do I have a second to ask you a question?
Excuse me?
Do I have a second to ask you a question?
As long as it doesn't incriminate yourself, Mr. Wright.
Yeah. So I know I didn't mean to.
I don't want to hear it. I don't want to hear it, Mr. Wright. I don't want to hear anything about what happened.
I would take
I'll answer your question if it deals with procedure. Okay? Do you have a procedural question for me?
No.
Okay. So how do you wish to plead to this charge? Either not guilty or no plea. Those are your only two plea options. Okay, the court is going to enter no plea on the defendant's behalf to this charge. Mr. Wright is currently being represented by the Public Defender's Office in another case which is set for a jury trial before this court. Are you asking the court to appoint an attorney to represent you?
Yeah. I'd like to plead not guilty because I didn't mean to do it. Yeah. I'm just being honest.
Stop talking!
All right.
Shut up about what happened. I don't want to hear that.
Okay.
So you wish to not plead not guilty?
I wish to plead not guilty.
Okay, I'll enter a not guilty plea to the charge. Are you asking me to appoint an attorney to represent you?
No, I don't need one.
Excuse me?
I think I can represent myself.
You're not representing yourself. You're currently being represented by the public defender in another case, right?
Yeah.
That you have pending in this court, right?
Yeah.
Has your financial circumstances changed at all in the recent weeks?
No.
Okay, I'm going to appoint the public defender's office to represent you. Now I'm going to address the issue of bond. The law director submitted a written bond recommendation asking that bond be set in the amount of $50,000, cash, surety 10%. The allegations contained in the bond recommendation are that on May 19th, 2025, the defendant started a fire in Kingsville Township in the brush and wooded area behind the Kingsville Motel, damaging 5 to 6 acres of property owned by Paulo Di Benedetto. Based on the defendant's criminal history, pending case before this court, and the severity of the charge here, I do find the defendant is a public safety risk. I do find that the bond recommendation is appropriate, and I will therefore follow the bond recommendation, set bond in the amount of $50,000. Cash surety 10%. And we'll set this case for a preliminary hearing in the very near future. Okay, Mr. Wright, do you have any questions for me?
No, sir.
Okay, this matter is concluded then. Thank you.
I wish there was a creator that would actually go back and check on these cases, but if I had to guess, he was probably some homeless guy living out in the woods behind a hotel and end up setting a fire and end up burning down around 5 acres. So, but yep, Donald saw the bump on my head. I hit my head on a piece of metal at work, and believe it or not, the metal was bigger than my head, and the metal did not move. My head did. It bounced pretty good. So, I learned that lesson. Problem is, I've learned that lesson many times before, and I just continue to keep learning the lesson. I got distracted. Critters here. Hey, Critter, how are you doing tonight? We got Judge Clark. Judge Clark is doing like a probable cause hearing in Panama City. It's a little long, but it's good. I like it, and it's neat to see how the mannerisms of the people there are different than they would be in Judge Simpson's court. So let's go, Judge Clark.
All right.
Oh, and I'm horrible at this. Thank you so much, Kim. Thank you so much, Donald, and thank you, Martha, for the super chats and memberships and that. Thank you so much. It's awesome to keep the lights on. It's good to keep the channel running. Thank you guys so much. I appreciate all of you guys watching. Some of these skills I'm having to learn a little better than others, but we're going to figure it out and we're going to get better at it. So thank you guys so much. I'll hit the play button.
State of Florida versus Theodore Alden Frater, case number 24 CF 531. Is that right? 242302. I'm sorry. All right. There we go. And we're here today based on an affidavit of violation of probation. And state ready to proceed?
Yes, Your Honor.
Mr. Meredith? Defense ready to proceed? All right, you can call your first witness.
Your Honor, the state calls Mr. Adam Jones.
Sir, if you just come to the podium, raise your right hand.
Someone's going to testimony you're about to give the truth, the whole truth, and nothing but the truth. So help you God.
Yes. All right. Mr. White, you may inquire whenever you're ready.
Hey, Big Tiff, that other court was in Ohio. The town starts with a C. I don't know if I'd ever be able to pronounce the town. I could live there for a couple of years, probably wouldn't be able to say it, but I'll send you the town in Discord. I couldn't begin to understand how to pronounce that name of that town.
Thank you, Your Honor. Mr. Jones, can you please introduce yourself?
My name is Adam Jones.
And what do you do for a living?
I'm a landscape architect.
Yeah. And what is your business called?
Renovo Landscape Architecture.
And are you familiar with a Theodore Prater?
Yes.
How are you familiar with him?
He was an employee of mine.
Are you familiar with a Timothy Hamilton?
Yes, he is an employee as well.
On February 21st of this year, did you give payments or checks for work done to someone?
Yes.
Who was that person?
I gave 2 checks to Mr. Theodore, Tim's and Theodore's. Tim was previously let go. He did not. We have a 90-day probation period with employment, and Tim did not make it through that. So I had let him go a day or so before that. So Theodore and Tim lived in the same housing unit. Theodore had recommended Tim to us, so I assumed they were on a friendship level. So I said, Ted, it goes by Ted sometimes, Theodore, can you take this and give this envelope to Tim, please?
And just to clarify, what was in this envelope?
Their paychecks.
Okay. And was it all in cash?
Theodore's was a check. Tim's was cash.
Okay.
But they were both sealed envelopes.
So there's two separate envelopes.
Two separate envelopes, one with Tim's name, one with Theodore's name.
And what did you tell Ted to do with the one for Tim?
Hand this to Tim, please.
Okay. At that point, were you involved with anything else related to a dispute?
I was not involved, other than Tim was calling me on the phone asking where his paycheck was. And I said, Ted was supposed to give it to you. They back and forth. Tim called the police. I was not there.
Okay. All right. Thank you. There are no further questions for this witness. However, hold on, sir. Okay. Sorry.
I'm Matt Meredith. I represent Ted. So Ted recommended Tim for the job.
Correct.
Okay, so he's the one that got him the job.
Correct.
But Tim didn't work out.
Tim did not work out.
So he was not working on February 21st. The day.
Correct.
And that's the Friday when you would pay your employees.
Correct.
So Ted was at work.
Correct.
He worked that day.
Yes.
And he got a check.
Correct.
And we keep calling it a paycheck, but I just want to make sure it was cash money for Tim.
Cash money for Tim.
11 $100 bills.
Yes.
And the envelope was sealed with Tim's name on it.
Yes.
Now, that was given, was it given?
I wonder how nervous this guy is testifying in court that he's paying the guy under the table. You know, we watch court all the time, so we know the judge really don't care, but he knows damn well he's paying the guy under the table. No one gives somebody cash to give their friend that's paying taxes on it. So it's fun to wonder how panicky he is.
Directly to Ted or?
Yes.
Okay. Now, do you know how Ted got back to the Ark where they were both living?
Yes. Another employee of mine dropped them off.
And you're sure that other employee didn't have the check or the money or any instructions about getting Tim paid?
Not to my knowledge. I handed it to Ted.
Now, the police were called a little bit after 5 p.m. Do you remember what time this envelope was given to Ted?
Usually we stop work about 3:30, 4-ish, around that time.
So stopped work, traveled back home. There's some concern about the Ted giving Tim the money all within about an hour.
30 minutes to an hour.
Not a very long time.
Not at all.
I don't have any other questions.
Mr. White, any redirect?
Briefly, Your Honor. Mr. Jones, were you aware of the living situation of these two individuals?
Yes.
Where were they living?
The Ark?
And what is the Ark?
It's some sort of home placement home run by a church organization that helps people get back on their feet.
Okay.
As far as I know, I'm not 100% on that.
Okay. And the envelope, you handed 2 envelopes to
Yes.
Mr. Prater?
Mm-hmm.
And both of these envelopes were sealed?
Yes.
And what was in the envelope for designated for Mr. Prater?
A check.
A check.
Mm-hmm.
And we've used words to define check a little loosely, but to clarify, you are talking about a
written check right out like normal.
Thank you. There are no further questions.
Barrett? Just briefly, I don't want to beat a dead horse, Mr. Jones. Ted's check hasn't been cashed, has it?
I do not believe so, no.
Okay. Because he only had it for about 30 minutes before law enforcement got involved, right?
That's yes, to my knowledge.
And if law enforcement hadn't gotten involved, Ted would have been back on the job on that Monday, wouldn't he?
Yes.
Anything else for the witness?
No, Your Honor.
Need to be excused?
You may, Your Honor.
Sir, you may go about your day. Thank you.
Thank you.
You can call your next witness.
Your Honor, the state calls Tim Hamilton.
Testimony you're about to give the truth, whole truth, the truth, so help you God.
Yes.
All right, you can put your hand down, sir. Mr. White, you may inquire.
Good afternoon, sir. Can you please introduce yourself?
Timothy Hamilton.
And are you familiar with a Theodore Prater?
Yes.
How are you familiar with him?
We work together and live together.
Okay. And where did you work together?
In landscaping.
In landscaping? Okay. Do you know who Adam Jones is?
This is the boss.
Who's your boss? Okay. Were you let go from that job?
Yes, I was let go.
Okay. And were you owed a final paycheck?
Yes.
You were?
Yes.
Were you aware of how much money that was supposed to be?
Yes.
How much money?
So just give everybody a heads up. This guy, as timid as he could be, as quiet as he could be, he's the one that the defendant stole $1,100 from. This guy's just as sounds down on his luck as could be, and the guy's trying to take his money. So, and unless you know how much sympathy you want to have for that guy.
What's that?
Like $1,100.
Okay. Had you and Mr. Jones talked about how you were going to get this money?
Yes, he was supposed to send it home with the editor or
Okay.
Ted.
All right. And
Michael, okay. Basic premise for this hearing is the defendant, the guy sitting in the jail uniform, was given $1,100 cash to give to the guy that's up in the middle talking right now. He told him that he did not get paid the $1,100 to pay him, and so they ended up calling the police out there. And while the police were out there, he ended up having the $1,100 in his pocket in an envelope with the guy's name on it. And so police got him for it, and this is the probable cause hearing.
where did Ted and you live together?
At the Ark.
At the Ark. And what is the Ark?
It's transitional housing.
Okay. And is that, do they help homeless people get back on their feet?
Yes.
Okay. On February 21st, were you informed that, let me rephrase, when did you first become concerned that you were not getting your money?
Well, it was when I called the boss because Ted was supposed to bring it home to me from work, and he never showed back up. And then all of a sudden he does, and he told me he didn't have it, so I called the boss, and he told me he sent it home with Ted. And then the police pulled up, and they heard him tell me that he sent it.
Objection, hearsay.
What? I believe hearsay is allowed in an evidentiary hearing. Is that correct?
I believe it can't be the sole basis for the.
Overrule the objection.
Okay.
Well,
let's just go ahead and stop and break this down step by step.
Okay, he lied in front of the police, and
Okay,
he
well,
stole
hold
my
on.
money, and I
I'd
want.
ask that he respond to questions and not testify in an area.
And sir, if you'll just speak up just a little bit, okay?
Yes, sir.
Thank you. Go ahead, Mr. White, ask your question.
So you became worried. You knew that Ted was supposed to bring you the money, and you became worried that he wasn't bringing it to you.
Yes, sir.
Okay. And you spoke to him, and he told did he arrive home?
Yes.
And did you ask for your money?
Yes.
And what did he tell you?
He told me that the boss did not give it to him.
Okay.
And
Hold on. At that point, had you already spoken to your boss?
yes.
And did you know that he was supposed to be bringing you the check?
Yes, I talked to him that morning.
Okay. At that, were you the one that called police?
Yes.
When did you call police, and why did you call police?
After Ted had got there, and he told me that he did not have my check, and the boss had told me that he sent it with Ted. That's when I called. And then he was on the phone, the boss, while I was talking to the police.
Okay.
And then they went in.
So the police arrived on scene in response to your call?
Yes.
At that point, was Mr. Prater still saying that he did not have the money?
Yes.
At some point during that interaction, did he pull out money and say, here you go, here's your money?
Yes, after the police asked him to empty his pockets. And he had his check and mine.
Hold on, just speak up where I can understand you, okay?
Uh-huh.
So at some point, he pulled out the money and said, here you go, and tried to give it to you?
Yes.
Okay.
What?
How much money did he have on hand?
He had $1,100 cash, which was mine. Then he had his check.
Okay. And that money, did when he pulled it out, was it still in the envelope?
Yes.
Okay. Was the envelope sealed?
No.
Okay. So he didn't have to tear it open or anything like that. It was already open?
Yes.
Okay. And did he say anything to law enforcement?
He told them to keep from fussing and arguing so much about it that he would just give me $1,100 that he had.
Okay. All right. Thank you. There are no further questions for this witness.
Mr. Meredith? Mr. Hamilton, have you ever been convicted of a felony?
Yes.
How many times?
I think 3.
Have you ever been convicted of a crime involving dishonesty?
No, sir.
Petty theft?
Yes.
Okay. How many times?
I think once.
Now, you were let go from this job landscaping, correct?
Yes.
And there was a job that Ted had gotten you, right?
Yes.
So you didn't go to work on that Friday, the 21st, right?
No.
Okay. You were just waiting around for payment, right?
Yes. At the ARC. I was on camera all day.
And Ted arrives home about 30 minutes before law enforcement's out there, right?
Yes.
Okay. And so within 30 minutes, you get 11 $100 bills from Ted.
No. No.
You didn't get the money.
No, not till after the police got there.
Okay. Well,
Well, they had to get the money from Ted, which he told me that he did not have, which the boss said that he sent to him.
You told the court he tried to give it to you, correct?
He said that he was giving me $1,100. The police asked where the money come from. He said, well, okay, I'll just give him this $1,100 to keep from arguing about all this.
Didn't you say it was in a
Yeah, in
envelope?
an envelope.
With your name on it?
Yes.
Okay, so he took $1,100 out of an envelope with your name on it to give to you, and it's your testimony that he's saying that was his money?
Yes.
And on that same day, after law enforcement.
Because he wanted the money back.
Let's
wait
for my questions.
Mhm.
On that same day, the Panama City Police Department released to you 11 $100 bills. So you were made whole.
Yes.
And that was within an hour of Ted getting back to the ARC from working, right?
Yeah.
Okay. And that was basically your severance pay because you weren't able to go back to work, right?
Yes.
Right. So you're not out any money.
No, I'm not now.
And at best, he didn't give the envelope to you for less than an hour.
Yes.
Yeah, so this lawyer just showed himself to be an ass. This lawyer here is making it seem like just because the police had to get involved doesn't mean the guy stole your money. Just because the police had to go and empty his pockets doesn't mean he wasn't going to give you the money. He just didn't give it to you until the police come to see you, making it seem like there's nothing going on there. So I know a lawyer has a job to defend their clients, but come up with something else. Blame the weather or something before you blame that. It was just a weak defense there. All right, let's go back.
Any other questions?
Briefly, Your Honor.
Okay.
Ted came home when you were at the house, right?
Yes.
And you asked him for your money?
Yes.
And he told you that he didn't have your money, right?
Yes.
And when the law enforcement arrived on scene and he reached into his pocket and pulled out an envelope and gave it to you, that envelope was no longer sealed, right?
Right.
Okay. There are no further questions.
All right. Can the witness be excused?
Yes, Your Honor. Please.
All right, sir, you can go about your day. You call your next witness.
Your Honor, the state would call Officer Davis.
Ma'am, if you'll come forward.
Always swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Good afternoon, ma'am. Would you please introduce yourself?
I'm Officer Leandra Davis with the Panama City Beach Police Department.
Were you working on February 21st of this year?
Yes, sir.
Did you come into contact with someone later known to you as Theodore Prater?
Yes, sir.
How did you come to interact with him?
Mr. Timothy Hamilton called the police. Originally it came out as a civil call, and then it turned into a theft call. He said that some money had been stolen from him by Mr. Prater.
Okay. So where did you arrive on scene?
Around the corner from the Ark, and then we walked to the Ark.
Okay. At some point, did you make contact with Mr. Prater?
Yes, inside the Ark.
What did you ask him?
I read him his Miranda rights, and I asked him if he had Mr. Hamilton's money, and he stated no. Multiple times he stated he did not have the money, and then he said he did have the money, but then it turned into, he said he had the money, and then he gave it to Mr. Hamilton in the shower room, which is the one room at the Ark that doesn't have cameras. And we just went back and forth between, I have the money, I don't have the money.
And at some point, did Mr. Prater present Mr. Hamilton with money?
I walked out of the room to run everyone on NCIC, FCIC. And when I walked back in, my Sergeant Caligieri, said he just gave him $1,100 in cash. It was $1,100 bills. And he said, I will give you this money if you don't press charges.
Okay. All right, there are no further questions for this witness.
Meredith, any questions?
Officer Davis, did you have a body cam
Yes, sir.
activated during your entire encounter with Mr. Hamilton and Mr. Prater?
Yes, sir.
Now, in your written report, you said Mr. Prater first said he was never given a check. He was only given an envelope with Mr. Hamilton's name on it, which he still had.
No, he never told me that he had it still.
Did you write this report?
Yes, sir.
Did he tell you that he still had the envelope?
No,
So that's a mistake in your report?
it must be a mistake.
Did you ever see an envelope with Mr. Hamilton's name on it?
I did not personally.
Was it ever collected?
No, sir.
Mr. Hamilton got his 100 or 11 $100 bills that evening, correct?
Yes, sir.
You were not present when Mr. Prater allegedly told Mr. Hamilton here's $1,100 in an attempt not to press charges.
No, sir, but he was demanding his money back when he got in the back of my patrol car since he was now pressing charges.
And the patrol car have audio and visual?
It does.
Do you know approximately what your response time was to get out there?
I came from the county pier, so maybe 3 to 5 minutes.
So less than an hour of Mr. Hamilton reporting this, he's made whole with money from an envelope that has his name on it. My client gave him.
I'm not sure where the question is.
My client gave him the $1,100 that Mr. Hamilton was owed, correct?
After law enforcement intervened, yes, and he said he didn't have it.
Was Mr. Prater, had he just gotten out of the shower?
I'm not sure. There was mention of a shower room.
You just come home from work.
No, sir.
I don't have any other questions.
Any other questions of the witness?
No, Your Honor.
Can the witness be excused?
Yes, Your Honor.
And you may go about your day. State and call your next witness.
The state, rest of the case, Your Honor.
All right. Mr. Meredith, you have any witnesses?
Well, Judge, at this time, I don't think the state's even provided a case from which you could find by preponderance of the evidence that Mr. Prater committed a theft.
I guess if that's a motion for judgment of acquittal or judgment, I'm going to deny the motion at this time. Find the state's met its burden at this point. Yes.
Okay. All right, we would call Ted Prater.
All right, sir, you just remain sitting there. If you'll raise your right hand to be sworn.
Solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
Okay, you can put your hand down. Mr. Meredith, you may inquire.
If you would tell the judge your full name.
Theodore Alden Prater Jr., sir.
Now, in February of this year, you were living at the Ark,
Yes, sir.
and you were working for Mr. Jones.
Yes, sir.
Had Mr. Hamilton been working for Mr. Jones as well?
Yes, sir.
Do you know how he got his job?
Yes, sir.
How was that?
I he requested if I knew anybody that would be willing to work, and I said, yes, there's guys here always looking for work. So Adam said he knew how to do masonry, so I asked if I could bring him to work, and he said yes. So I got him the job.
Did it work out for Mr. Hamilton?
Well, it worked out at first, and it rained one day, and we didn't get work, and he sent a cussing message, upset about not working, and I told Mr. Jones maybe it's best to let him go because he seems like an aggressive, angry guy. But Mr. Jones decided to keep him on for a few days more, and until this incident happened. But yes, he worked for a week and 3 days.
Now, on February 21st, were you at work?
Yes, sir.
All right. Was that payday?
Yes, sir.
All right. And
So the guy everybody is saying is monotone, the guy that everybody said was sleepy. He's talking about how the guy was too aggressive and the guy was too mouthy and just couldn't handle a landscaping job.
how were you to be paid?
I got paid with the payroll check because I was the only one on the payroll at the time, besides Christian, which was the driver who was transporting and picking us up from work, which was the crew leader.
So you're on payroll, so the government takes out their FICA, Social Security, all that kind of thing?
Absolutely.
This envelope for Mr. Hamilton, can you explain to the judge how it came into your possession?
It's exactly the same as my envelope, except it had Tim on it. Mine had Ted. And Mr. Jones walked over to my door. I was in the passenger seat of the truck, and he gave me my check. And that is the only envelope that he handed to me personally. He walked around back to the driver's side, and he handed Mr. Irwin his check, which he was another employee that I just had got a job. And his check was in cash because he was an undocumented. He was in the process of becoming legal, but he did not have the Social Security number to be a tax-paying citizen yet. But his check was in cash. So he told him, be careful, that's a lot of cash. And it was a lot of cash. And then he handed the driver, his name is Christian, he's a great guy. And he handed the driver Tim's check or envelope. And he put that on the center console of his dash, or in the middle of his on his console. And he said, make sure Tim gets that.
Did Christian drive you back to the Ark?
Yes, that's when Christian and all of us went back to the Ark. And that day.
Did Christian live at the Ark?
No.
Okay.
No.
Did Irwin live at the Ark?
Yes.
Okay. When you got back to the Ark, Irwin and you get out of the vehicle.
Yes.
What happened to the envelope with Tim's name on it?
Well, it was sitting there in the front, and I asked Christian, I said, do you want me to tell Tim to come out here, or do you want me to give it to him? And he said, just give it to him. Because go ahead.
That was at the Ark, you have roommates. Was Tim a roommate?
We were bunkmates.
Okay.
I slept on top, he slept on the bottom.
Okay. Did you take Tim's envelope to give it to him?
I took the same route every day, the only way in, and I walked through the dining area. I went straight to my bedroom. He was not there, so I went to take a shower.
Okay. Did you see Mr. Hamilton before law enforcement got there to talk to you?
Not at all. Never laid my eyes on him.
Did you ever take the contents of the Tim envelope out of it before you handed it to Tim?
Absolutely not.
Did you know how much money was in there?
Absolutely not.
You did try to give it to Tim after you spoke to law enforcement, correct?
Well, the only time I seen Tim was after the police walked into my room. I was getting dressed because I just got out of the shower, and the gentleman was the first one that came in my room, the officer gentleman, and the ladies, they were a little behind, so he told them he's not dressed, but they still came around because they just didn't have a shirt on. And Tim was there with him, and also a couple of other residents. And that was the first time I laid eyes on them. And they said, we're looking for Mr. Hamilton's money, or for his check. And I said, well, he didn't get paid a check. He got paid cash.
Did you tell law enforcement that you didn't have his check, or what did you specifically say?
Well, my specific words, his specific words is, we're looking for Mr. Hamilton's check. And I said, he didn't give me a check. He gave me an.
I got a comment on the judge right there. Look at the judge's face. You can just tell he's just bored with it. He'll let the guy just sit there and lie, and then send him on.
Envelope with Tim's name on it with cash, because he told me, be careful, it's cash,
Did you intend to keep Mr. Hamilton's money from the work that he had done?
Absolutely not. I took care of him all week.
Did you get it to him as soon as practicable once you got back to the Ark?
As soon as I laid eyes on him. It was Friday. I was ready to take a shower. So I did that because I knew I'd see him. He was my bunkmate. And I had a $2,000 check in my pocket that was mine.
Did you ever cash that?
It's still in my personals.
So did you intend to either temporarily or permanently keep that money from Tim Hamilton?
No, we were friends.
I don't have any other questions.
What?
Briefly, Your Honor. Mr. Prater, have you ever been convicted of a felony?
Yes, sir.
How many times?
I honestly don't know. Multiple. 2. Let's say 2. 25 years ago.
Are you on probation from 25 years ago?
No. No, sir.
All right. You worked for, you and Mr. Hamilton worked together, didn't you?
Yes.
And y'all both worked in landscaping, right?
Yes.
Y'all both were living together at the Ark, right?
Yes.
And you were both trying to get back on your feet?
Yes.
Yeah. And you were handed, you received an envelope from your boss designated for Mr. Hamilton, correct?
Not directly, but yes.
Eventually you received it
Absolutely.
and you knew that it was supposed to be given to Mr. Hamilton?
Absolutely.
And you arrived at the house where, and you came into the room that you both share, right?
Absolutely.
And then you never laid this check out, did you?
I never opened the envelope.
Well, no, what I'm saying is that you never laid it in his room or anywhere where he could find it, did you?
We were bunk mates.
Okay, and you didn't leave it on his bunk?
No, I wouldn't leave $1,100 cash or an envelope of cash anywhere.
Okay. Did anyone else share the room with you?
7 other men.
Okay. And when the officers arrived on scene, you didn't immediately hand the envelope to them, did you?
No.
You didn't?
I didn't really know what it was about.
Okay. And you said that you told the officer, is it your testimony that you told the officers that you had a check on you and that it was designated for Mr. Hamilton?
Well, I had a check on me designated for me, but I had an envelope on me designated for Tim.
Okay, and that's what you told them?
I have his money, yes.
Okay, so is it your testimony that Officer Davis was lying about the fact that you didn't have the money on you?
Objection calls to comment on another's testimony.
Can you repeat?
Is it your testimony that Officer Davis was lying when she said that you told her originally that you did not have Mr. Hamilton's money?
Well, I think it was misinterpreted when I said I didn't have a check. Because I didn't have a payroll check because he asked for a check. And I said, I don't have a check. I have an envelope of cash. I do have his money, was my words. Yes.
So you're saying that she was lying?
If she said that I said I didn't have the money, then yes, she was lying.
Okay. And it's also your testimony that Mr. Hamilton is lying about you explaining that you had already given the money to him?
Well, yes, I had never laid eyes on him, so how could I speak to him when I hadn't seen him?
I apologize, sir. I was a little mistaken. Let me rephrase. Where did the statement that you had given it to him in the shower come from?
I have no idea. The air. I've never heard it before.
Okay. There are no further questions, Your Honor.
Mr. Meredith, any other questions?
No, sir.
All right, you can call your next witness.
That's all from the defense, other than argument.
All right, Mr. White.
Your Honor, we have heard the testimony of Adam Jones, who was the employer of both of these individuals. We've heard his testimony that he handed an envelope or distributed an envelope to Mr. Prater that was intended to be given to Mr. Hamilton that had $1,100 for his severance pay, the money that was left after he was let go. We have heard the testimony of Mr. Hamilton, who has explained that when Mr. Prater arrived at his house, he asked him for his money, and Mr. Prater said that he did not have his money. And we have the testimony of Officer Davis, who explained that when she arrived on scene and initially started investigating, that Mr. Prater stated that he did not have the money for Mr. Hamilton. And once sufficient officers were on scene, he eventually decided to pull out an envelope with $1,100 in it. And Mr. Hamilton testified to the fact that that envelope had already been opened. And Mr. Jones testified to the fact that the envelope had been sealed at the time that it was handed over. Mr. Prater had the envelope. He had no intention of giving it to Mr. Hamilton. He had already opened it, even though it was sealed and designated to Mr. Hamilton. Regardless of whether or not there was a 30-minute time period or an hour-and-a-half time period or any of the like, Mr. Prater was clearly intending to permanently deprive Mr. Hamilton of the money. It would not have handed the money over except for the presence of law enforcement and him wanting to try and get this charged or get this resolved without being charged.
Mr. Meredith.
Yeah, I do think the timing is very important. Mr. Prater worked that day, came home from work, and based on the Mr. Jones' testimony, it was within 30 minutes tops that this whole thing became involved with law enforcement. Officer Davis said response time was 2 or 3 minutes. And she admits that I guess she thinks it's a mistake, but she put in her written report that Mr. Prater stated he never was given Mr. Hamilton's check and was only given an envelope with his name on it, which he still had. Officer Davis says that was a mistake. He never said that he still had it, but she had body cam, which the court does not have the benefit of. Mr. Prater never had a check. He had cash for Mr. Hamilton. Mr. Hamilton got those 11 $100 bills signed over to him from the Panama City Police Department within a matter of an hour in terms of getting the envelope to the investigation to releasing the money to Mr. Hamilton. He wasn't even temporarily deprived of it. Mr. Hamilton and Mr. Prater both have extensive records. So I believe Mr. Prater's testimony is more believable in that he got home from work, and you know the type of work he does. He doesn't see Mr. Hamilton, so he takes a shower. Law enforcement's there, and within a matter of minutes, Mr. Hamilton has his envelope with all the money there. This is not a willful or substantial violation of Mr. Prater's probation, and I ask that the violation be dismissed.
Based on the testimony I've heard, that consistent testimony is the witnesses called by the state. The inconsistent testimony is by the defendant. I am going to find that he willfully violated the terms and conditions of the violation by either temporary or permanently attempting to deprive Mr. Hamilton of his money. We'll find he willfully violated the terms and conditions of his probation. Do you have a score sheet prepared? If you'll come forward with the score sheet. And while he's doing that, Mr. Meredith, do you have an idea how much time Mr. Prater has served?
274 days on the probation case.
274 days. If you'll allow Mr. Meredith to observe, to review the score sheet, and then if there's no objections, if you'll file it.
Statutorily, he's qualifies as a violent felony offender of special concern because he does have that prior for the robbery. That's what makes it the 12 and not the 6 for the technical violation.
They want to be heard on sentence. Why?
Your Honor, given the circumstances of the defendant's criminal record, as well as the testimony that we've heard today, the state would ask that you sentence the defendant to 24 months in the Department of Corrections.
Okay. Mr. Meredith?
Honor, based on the fact that the score sheet's still under 60, the court has its discretion not to
I'm gonna revoke his probation, adjudicate him guilty of felon in possession of a firearm ammunition, sentence him to 24 months in the Florida Department of Corrections, give him credit for 274 days time served. All fines and costs that were originally opposed and have not been paid are reduced to a civil judgment. I am going to also impose a $250 fee for the cost of the prosecution of the violation of probation. That will also be reduced to a civil judgment. Mr. Prater, you have 30 days to file your notice of appeal. If you wish to appeal your judgment sentence, if you'd like to have an attorney to represent you and you can't afford one, one may be appointed to represent you at no charge. You need to step over and be fingerprinted and do, is there something we can work out this week on the new charge? We need to set it off for a pretrial.
If the state has an announcement, we'll accept it. The state's benefit, Mr. Prater put down is the time on the new charge.
Okay.
Yep, so he had gotten probation for the felon in possession of a firearm, and while he's out on probation, he does this stupid thing, and so in the end, I guess we're all going to be better with him being in prison for 2 years. All right, we're going to go to Judge McNally. We had an interesting one in Judge McNally today. Here we go with that.
Good morning, Judge. Bianca to you on behalf of Miss Shiana Beard.
I'd like to know if the victim is here on this case, either in person. Come on up here.
State your name. Shiana Beard.
Right over there, it doesn't look like one, but that's a microphone on the jury box. You can go, you can stand outside the jury box. Come on over around here. And I just want to make sure we pick you up. What is your name? Defendant pled guilty here, or no contest, I should say, to telephone harassment. And the plea was to be taken under section 771.1. Have you had a chance to review the report with her, and are there any material additions, corrections, or deletions?
I have, Your Honor. There are no additions, deletions, or corrections.
Anything you would like to say on her behalf?
Yes, Your Honor. When it comes to fines and costs, I would ask that you take into consideration that Ms. Beard is not employed at this time. She's looking for work. She does have. Oh, she's employed.
Yeah, you're making good money. 1,200 a week, right? Right?
And she, yes, Your Honor, has 2 minor children, Your Honor, and she does have a personal protection order against the victim. Your Honor, this is a family matter. The children have been contacting Grandma, and Miss Beard is requesting that the victim not contact the minor children in this matter. And I'm stating that because I don't know if it's in the file that there's been a report that Miss Beard has been trying to contact the victim. She is not.
I'm gonna listen to everybody. I'm not gonna say anything at this point. And I just need to read you this. Did you see this note from Ms. Fowler?
I did, Judge.
And you covered it with your client?
I did.
What is the relationship between the two of them?
So the victim is the mother of Miss Beard's children's father. She's the.
Wait a minute, slow down.
I'm sorry.
She's the mother.
She's the paternal grandmother of Miss Beard's children.
Is that right?
That's correct. My son Kurt has been dating for 17 years.
Okay. Okay. And she has a PPO?
I have one out on her.
I thought you said she had one.
I have one as well, Your Honor. There is PPOs on both ends.
No, it's my first.
Okay, wait a minute, ladies. Anything else?
No.
Anything anything you want to tell me?
No, Your Honor.
Your Honor, she has a assault case in Taylor that's going on right now.
I read that. I read at least you said that you were assaulted on or
Yes,
about,
brutally assaulted.
what was the charge? Is it assault and battery or
No,
something?
they trying to do, disorderly conduct. And I'm upset about that. And this phone harassment case, she's been, phone harassing me for 7 years.
I'm having a hard, hang on. I want everybody to stop right now. I'm having a hard time with this. I really am. I don't understand this. I don't understand this. I mean, I've said it before here. If we all lived until we're 890, then, you know, you could take a few years and be a screwball. We don't have that long on this planet. I don't know why this would go on between the mother of, ma'am. Now, I want to caution you.
I'm just,
Ma'am, while you're kind of acting, so far your body language is telling me that there are reasons that you think that your conduct was justified. If I misread that, that's fine. Maybe I did. I want to read some of the things I read in the report.
Mhm.
She's reporting to the police that you've been harassing and threatening her over the last year. She says she's told the police that she told you to stop contacting her and you haven't. She says that you're using Denzel Lamont's phone number. Is that your son?
Yes.
And Denzel Lamont's son's phone to call her because Sheena Beard knows, because you know that she's blocked your number.
Yes, sure.
She says you told her over multiple phone calls that you have a CPL and will use it. Do you have a CPL?
Not anymore, Your Honor.
Did you then?
Yes, I did.
She also says you threatened, quotes, to kill her, quotes, kick her ass, and wish death upon her. Now, I gotta tell you, at least where I come from, how do I put this delicately? How do I put it delicately? My wife is a wonderful grandmother. I'm not here to talk about my wife. I don't think we have enough support systems to turn down help from somebody else. And now you don't want her to call her grandkids, which I think is just.
Your Honor, can I speak? I'm sorry. I'm sorry.
No, you can go ahead.
I'm sorry. When I was agreeing with you earlier, I was agreeing that it's been going on for too long. It's family issues. She doesn't feel me and my kids are her family. I have screenshots, I have messages as well. This has been going on for too long. They have assaulted me before. Her and her 2 daughters as well as this. I'm in a toxic, abusive relationship with her son. That's the part she don't mention. They all have attacked me before at one time together. I have messages where she was just telling Denzel to tell me the kids are not hers, the kids are not his, they need to be took by CPS. F me, she sent us, it's been going on and it's not just on my end. Your Honor, it's a family issue because of a toxic relationship. That is the truth.
How do you get along with your son?
It hasn't been good since she used to enter our life, since I let her in when they was 17 and 18, 16 and 18.
I met Denzel at 14, Your Honor.
And she lived with me half of the time.
Ladies, I can't pick you both up.
But
Maybe,
Your Honor, she hasn't started me, this is what's not being on the record, 4 times. This is the 4th incident that I have put up with her assaulting me. This is the 4th incident that they won't let me get out on the record.
I'm not gonna comment other than to say this is going to stop. I promise you it's going to stop. If it doesn't stop, you're gonna force me to do something I don't wanna do, but I will do anytime if I find out you have any contact with her. You will have your 771 status revoked and you will go to jail for 90 days. So if it's worth it to you,
No, Your Honor.
if it's worth it to you, just call her one time and test me.
No, Your Honor. I just have a question. If I could just say one thing. The last time I was here, Your Honor, she told the prosecutor that I was contacting her. That was not true. Then the prosecutor came to me the next time and said, she reneged.
She says on August 17th to 24, a block number called 29 times from 8:37 until 9:42 in the evening.
That's correct.
That's a black number. That's not my number, and that's August of 2025.
Ladies, I can't pick up two people talking at the same time. I just can't do it. She's got to take down everything that's being recorded here. I don't know what to tell you two. I can't solve this. I cannot solve this. If you guys want to go on being like this, where there's animosity between living girlfriends or spouses or whatever the case may be, and grandparents and children not seeing their grandmother, I don't know what to tell you. I really don't. I cannot solve every single problem sitting here. I think it's sad. I think it's extremely sad. I think you got an anger issue, and I know you're going to stop calling her like this. I know that if some grandmother has to block a phone number of somebody who is the mother of her grandchildren.
She said they're not hers. She said that she need to get took and was talking about my kids. She don't believe they're.
That's incorrect.
I apologize.
You're not helping yourself. You want to help yourself? Listen to me talk. You don't want to help yourself? Keep interrupting me and keep interrupting her. I don't know what to tell you. But I'm dead serious. I'm serious as a heart attack when I say if you contact her again, you're going to have a massive problem with me. 12 months probation unless somebody has something else to say, I'm ready to sentence. You have something else to say?
That's it, Your Honor.
You have something else to say?
No.
You have anything else to say?
No, Judge, thank you.
12 months probation. You cannot, I'll take it under 771.1. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No contact with Cherie Fowler. You cannot write, phone, see, text, email, or communicate with her in any way or have anybody else do any of those things for you on your behalf. I'm not threatening. I'm promising you contact her. You're going to jail. Do you understand?
Yes, Your Honor.
You're not to possess firearms. You're not to possess dangerous weapons. You're to attend an anger management program with 8-week follow-up.
Yes, Your Honor.
You are to serve 3 days on the court work program. There's a $35 a day charge for that. That's $105. Again, no firearms, no dangerous weapons. The threats thing I don't get. I just don't understand the threats. All the violence goes on out here. It's just insane to me. 100 fines, 200 costs, 75 victims' rights, $50 justice assessment, $60 screening fee. For 485, probation fees are $240 for 725, charging attorney fees of $40 for 765 plus court work program fees. $870 is your total. If you violate, your probation could be revoked. You could be incarcerated for 90 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. You do everything I said. I'll be happy to dismiss this case. It will be on motion of the prosecutor in a year. So I'm going to need a review hearing date. And also, by the way, why do you think you don't have to take care of warrants?
I am, Your Honor.
You are. You are going to do, listen to me. You're to clear all warrants within 21 days. Do we understand one another?
Yes, I thought it was 60 days.
They recommended 60. I think it'd be nice. You stop doing this.
Okay, I agree.
All right, now, give me a review hearing date, Lisa.
May 13th of 26 at 9 o'clock.
God willing, May the 13th of 26 at 9 o'clock, we'll all be back here. I'm telling you, will you please think about what I'm saying?
I hear you.
Don't you think it's important for grandparents to be with their grandchildren? I sure do.
I do, but she don't want to be a part of my kids.
Can I ask you a question?
It's nothing.
I'm not condoning her conduct here at all. I think I've made that abundantly clear. Do you believe I've made that clear?
Yes.
If you don't think they're her grandkids, your grandkids?
Your Honor, I have concerns about those children being my son's grandkids.
All right, well, but you don't have any proof, so wait. That's hurtful things to say if you're not correct. Do you understand?
My son.
That is hurtful.
My son has said it.
Well, then maybe
Because
he
Ms. Beard was gonna take him for child support, because he works at Forest, and he said he's gonna receive a paternity test.
Okay, well, maybe you should go get one. I don't know what to
That's
tell
what
you.
I told him.
Review hearing, May 13th, 26, 9 a.m. Ma'am, can you pay all of this today?
No.
How much can you pay today?
I can do $100.
And then how much can you pay weekly? You got a good job. Can you
I
pay
do
75 a week?
Yes.
75 a week, you get paid every week, right?
Yes.
I'm gonna start this beginning June the 6th. If you ever don't have the money, no problem, don't be afraid. I'm easy to get along with if you don't ignore me. So you call the court or you come in here on or before the due date, I'll be more than happy to give you an extension. Just don't ignore me. That's not so nice, okay? Good luck to you both. I wish you well.
Thank you, Judge.
Thank you, Marshawn Andre Moody, 25B14809 2A and C.
Deanna Petito on behalf of Mr. Marshawn.
Marshawn Andre Moody.
All right, so he pled the resistant.
All right. I should have cut it off earlier. I didn't pay no attention. Thank you guys so much for coming out tonight. We're going to figure out this daytime stream, the early morning stream sometimes. I could edit some videos and have 3 or 4 hours of videos for us during the day, or we can just continue the court hop and make sure to let us know what you want, because we're somewhat lost. You know, we had all our hopes on Judge Fleischer, and whenever that didn't work out, we're just somewhat all lost. There's a little bit of depression in there, just a little bit of gloominess, but we'll get past it and we'll figure out what we're going to do there. No, Cher, no one's giving me a hard time. At least if they are, I hadn't noticed. I'm not good at paying attention, so I will go for that. If your name's not on the ending credits, make sure to get it with Linus. She sent me a couple, and of course I missed it. So just make sure to keep on her about it, and I'll get it fixed up. Thank you guys so much, and we'll see y'all tomorrow morning.